Today's question has to do with creditor claims and real estate. The reader asks, can creditors put a lien on our mother's house from one of our siblings whose name is on the deed and owes creditors but has passed? One of our siblings who is listed on the deed of our mother's house has passed and owes substantial amount of medical and other debt. Could they put a lien on her portion of the house even though she is deceased? So it sounds like the mother put her children on the name of her deed of her current home, but the mother's still alive. Now this is unfortunately a very common estate planning technique where the parents try to avoid probate on their death by adding the children to the deed while they're alive. The reason I often warn against this is exactly what's going on here. If you put your children on the name of the deed now, they become current co-owners of the property. That means if they have creditor issues and the creditor goes looking for an asset to put a lien against, it's very easy to research the real estate records and see that your son or daughter's name is on the deed to your house. Now oftentimes you work your whole life to buy a house, pay it off, and have it solely in your name. So when you put your child on there and they unfortunately, sometimes through no fault of their own, like in this case, have medical bills, that asset can become subject to claims of creditors. For this reason, I recommend you leave your home at death to your children through your will, or the best is to avoid probate by leaving it through a trust. Then it transfers at death, and they also get the step up or new basis upon your death, so that if they sell the home, they take the asset at the basis it's valued at your death versus the basis you bought it at. And what I mean by basis is the tax basis. Often, if you owned your home a long time, you bought it many years ago for a much lower price. When your children go to sell it, they would owe capital gains on the difference between what you paid and the price they sell it for if you add them during your lifetime. If you leave it to them at death, the tax law grants them what we call new basis at death, and they can often sell it at that new basis and owe little or no capital gains at the 15% tax rate. So I'm sorry to hear about this situation, but because your deceased sibling is on the deed, it's possible the creditor could go after that asset. Now, if your sibling passed away and there's been no probate opened, you'll have to see what's going on there with creditor claims. Generally, for the deceased sibling, there's a period of time for creditors to present claims, so you may or may not want to open a probate for that sibling in order to get that timeline running. I recommend you speak with an experienced probate attorney in your area before you proceed, because there's a lot of issues here, and doing it one way versus the other could end up costing you and your mother and your house a lot of money. So good question, and thank you for asking.